President, New York State Funeral Directors Association. Just want to welcome you all today to our webinar today. It was really nice to have our retired Bureau Chief, Tom Fuller, with us today. And before I turn it over to Kelly, I just want to go over some announcements and some things that the association and the board of directors have been working on. If you could, please keep your eye out for an email later on tonight. We have our next newsletter coming out with a lot of information that we're going to cover over the next couple of weeks, and some catching up that we needed to do with you guys. There'll be information in that newsletter, in Mike Lunati's report and my report, in regards to the legislative update and the survey that's ongoing for the legislative update. Please be sure to check that report that's in the newsletter, and make sure you read back to your emails so that you can complete the survey. Unfortunately, some of you may have heard and seen in an email, but the nursing home refrigeration bill was vetoed by the governor. Currently, we're assessing the next steps of what we'll be doing with that bill and moving forward on it. As you know, we have been talking about hosting town hall meetings virtually. We had our first one last Thursday. We have our next one this Thursday. This Thursday, we'll be visiting virtually with regions 3, 4, and 5. So if you're in those regions and you got the email, please do check the link for that and sign up and get in on that link. We'll be starting the meeting around 7 p.m. Where we'll be going around the different regions, getting information from you guys, and we'll be talking about what's going on in the state level, and some new and exciting things that I'm going to mention next. In case you haven't seen or heard, the Northeast Partnership, in conjunction with New York State Funeral Directors, New Jersey Funeral Directors, Pennsylvania, Connecticut, and Massachusetts associations, are starting up the Certified Funeral Service Employee Certification course. It's similar to the one that was done last year, but that was for management. This one is more for the employees of your funeral home. It is geared for those that work in your funeral home, the funeral directors that work in your firms, including New York State residents. See if your staff is interested, and we encourage them to take part in this exciting opportunity. And we just got word that the Bureau has offered 6 CEUs for the completion of this course. Lastly, I'm pleased to announce and share that the board has retained Zogby Strategies out of New Hartford, New York, to partner with us in conducting the business analysis of the funeral services in New York. This is something that we've been talking about and working on for a good part of last year into this year. And we just wanted to announce that to let you know that that's what's happening. So you got a little snippet of what we'll be talking about tomorrow night in regions 3, 4, and 5. We already talked about some of these things in 1 and 2. So hopefully we'll see some of you tomorrow night. And then after that, just a reminder, we'll be in 7, we'll be in 5 and 6, and then 7 and 8 the following 2 Thursdays consecutively. So with that, I'm going to turn it over to Kelly. It's all yours, Kelly.
Thanks, Mike. Good afternoon, everyone. Thanks so much for joining us today. Feels a little more like fall out there than it has been. Just a few housekeeping items as we get started. So you were asked to insert the names of all of those who are sitting in on the webinar, just as you always have. Please make sure that everyone was pre-registered for this webinar and then listed again on the registration process as you got into this webinar. If someone was not listed, please reach out to me via email and add their name. If you have questions during this webinar, please type them in the question box. Following this webinar, we are asking you to give us 7 to 10 business days for your portal to reflect your credit, and you will also receive a letter. If you get dropped from this webinar at any point, please get right back on, but then also notify us that you were dropped so that we can make sure our records indicate that. Also, at this time, I'm going to give you a number that you need to write down and remember, just in case you are asked. This number does not need to be emailed to me. It's just in case that you are asked. And the number is 3434. I will give you another number at the end of the webinar, and you will need to hold on to that one as well. At this time, we would like to welcome Tom Fuller. Tom, as everyone knows, was our former director at the Bureau of Funeral Directing. He has since retired, and we are so happy for him as he has moved on to teaching at SUNY Canton. Welcome, Tom.
Well, thank you. Thank you for asking me to do this. As Kelly mentioned, I'm no longer working for the Department of Health, but after 9+ years there, I had already committed to doing some continuing education with Kelly. So I wanted to express, some of that knowledge that I've gained over the last decade. And again, I'm not speaking on behalf of the Department of Health, but I am teaching. I'm still with the state in the way that I'm now a adjunct instructor at SUNY Canton. And so I'm working part-time, so it's kind of a semi-retirement. But after being at the Bureau, it feels like a pretty full retirement so far. So the format today is Kelly solicited questions from the members, and I'm going to try to respond to them as best as I can. Okay, so this first one is regarding a fetal death. It says a family contacts a funeral home regarding a miscarriage that happened in the hospital at 12 weeks. The hospital is insisting that they will only release the remains to a licensed funeral director. The family wants to bury the remains on their own property. What is required by the LFD? So I know the 12-week mark, as far as I know, that has not changed. If the gestation is under 12 weeks, the state can consider that, the hospital can consider that a product of conception, but not necessarily a fetus. Even if it's under 12 weeks, if a family wants to have a burial in a cemetery or something of that nature where they are going to need a burial permit, the hospital is allowed, regardless of the length of gestation, to issue a death certificate. So in this case, though, the hospital is insisting that they will only release to an LFD. It doesn't say whether or not there's a death certificate involved in the situation, if the family has requested that. If the family requests a death certificate, then they would have to. So I'm not sure if that was the case in this question, that they had a miscarriage at, say, 10 weeks, and they wanted to have a religious service and a burial in a cemetery, then they would need the death certificate, in which case the hospital would have to release to a funeral director, because only the funeral director can file the death certificate and get the burial transit permit. So as far as burying on their own property, the first year I was with the Bureau, that came up, and I was surprised to learn that that is allowed. In the case that I dealt with, the state police became involved, and we spent a couple of days phoning around the state trying to find out what the actual rules were. The only drawback in that situation was the woman that buried the remains buried them on the property, but she did not own the property. She was a tenant. And so the landlord got involved as well, but that's a whole nother situation. So hopefully that gives you some direction on that. Again, if the family was insisting on a formal disposition, then they would have needed the funeral director. See if there's any questions on that. No? Okay. So the second
They're
one,
actually, go ahead.
So I think what I'll do is I'll stop every couple of slides and see if you've got any fresh questions that came in, and then every 5 or 6 slides. So when the 120-day mark approaches for unclaimed cremains, is it a good practice for the funeral home to mail a letter to the family? Yeah, that's obviously a good practice. It's not required. The family should have been given the designation of intentions at the time of the arrangements, which explained that there was 120 days for reclaiming them. One thing that has cropped up in the years I was in Albany was this fad started going around to funeral homes asking the families to put like $100 deposit on, that if they picked up the cremains, it would be refunded. That is not legal. It says right on that designation of intentions. The CDI is very specific. It says they have up to 120 days to pick up those ashes. They can't be penalized if they don't. They can't lose a deposit if they don't. But the firm may dispose of the unclaimed cremains. They have to just keep a written record of how that was done. So yeah, this is obviously good practice. You know, if you do have cremains and people are being slow about it, it doesn't hurt to remind them that the 120 days is approaching, and at such and such a date, we're going to dispose of so-and-so's cremated remains. And I would assume that would get some response from a family unless they're completely uninterested. Return of cremains. Is the funeral director responsible for ensuring an individual's intentions per the customer's designation of intentions form is carried out when it comes to distributing and sharing cremains? No. That's the short answer. The long answer is we probably got this call 3 times a month where the funeral director, again, that goes back to that CDI. How did you fill that out with the family? If they want to divide up the ashes and the cremains afterward, don't put yourself in the middle of that. Unless you're selling them, a series of smaller urns or cremation jewelry, you should designate one person that's going to be receiving those cremains. And then if there's a dispute afterward about how they're being distributed or how they're being divvied up, let them fight it out. You don't want to spend money on an attorney just to find out that it was their responsibility anyways. So you're not responsible for ensuring their intentions. They have a customer's designation of intentions that should say either A, we're going to bury, B, we're going to take them back. The most common mistake I see when those phone calls would come in, this first thing would say is, how did you fill out the CDI? And they'd say, well, return to family. And there's the downfall there, because the family can be a lot of different people and you can have multiple people in the same category with the same rights. And it was almost invariably, everybody's on the same page when it comes to having dad cremated. And then, Billy shows up to pick up the cremains and you say, well, I gave them to Susie. Well, why did you give them to her? I'm the one that signed the itemization. And then you get pulled into a fight. And that always turns out, what did you put on the CDI? Return to family. So be very specific. And then you don't have to worry about ensuring that their wishes were carried out. You leave that carrying out the wishes up to the family member that's designated to receive the cremains. Is a signature required when releasing cremated remains? Yes, the second half of the CDI is actually a 2-part form, and you're going to use it twice. During the arrangement, you fill out the top half where you have to specify the name of the deceased and all that information, what the intentions are the customer. If it is returned to the customer, make sure that's filled in. It has to state what will happen with the cremains after 120 days and how they would be disposed of. And then there's a second half that is reserved for use after the disposition has happened. So when the ashes come back to the crematory, that portion is filled out. And if you are returning the ashes to a specific family member, they need to sign that. I've had a few cemetery people kind of look at me funny because I would, if the family wanted the ashes buried, I'd meet them at the cemetery and would have the service, and I'd bring that CDI over to the cemetery office, and I'd ask the sexton or the caretaker to sign to say, yes, these were buried on our cemetery. So then you have a copy of it. And the family is supposed to get a copy. I know they usually get the copy when you do the first half at the arrangements, but the completed CDI, they're also required under the regulations to get a copy of that. What options exist for a funeral director who wishes to dispose of unclaimed remains that date back before the implementation of the designation of intentions form? It's not specific in the regulation, but I think the spirit of the law was they don't want funeral homes left with boxes and boxes of cremated remains. So the fact that the cremation may have taken place before the form was required, I still think the spirit of the law is that it's long enough where the funeral director can do a disposition of those cremains. I would always recommend that you do a good faith effort to contact those individuals. It's just like the cemeteries do when they're applying to the cemetery board to fix a monument. They have to make a good faith effort to contact the owner of the monument and the existing family members. So I would think the same thing would apply here. You make a good faith effort to contact them, document what you're doing with the cremated remains, and then if God forbid they show up, 25 years after the cremation, at least you can give them some direction of where those remains are. Agent forms. Okay. If a person lives in Pennsylvania but is pre-planning in New York and intends on using a funeral home in New York, will an agent form be valid? The agent form is dealing with what should happen with the individual at the time of death. So what is the overall guiding principle here is where does that person die, not where do they plan to be buried or which funeral home they want to use. So, and this actually came up, we had a family dispute in which naturally they tried to drag the funeral home into it. We had in the southern tier, many of you are familiar with Robert Packard Hospital. It's in Sarah, Pennsylvania, right across the border from New York. So we have a lot of New York families that have individuals go to Pennsylvania and end up not coming back alive. And we had a situation just like that where the son was listed on the face sheet at the hospital as a next of kin. He wasn't the one that had full rights of disposition, but the hospital in Pennsylvania recognized him as next of kin. And when they contacted him on the death, he gave them the instructions the body is not to be released to anybody without my say so. So naturally there was a dispute between him and his siblings. He was doing a power play to take control over everything. He did contract with a Pennsylvania funeral home and tried to get the body out. It ended up going to court, and I don't remember the full outcome, but it had to go to court in Pennsylvania. So even if he had a valid 5211 filled out, Pennsylvania probably does not recognize that because it's a New York form. And they may have a form similar of their own, but they would probably expect that would be used. So it all comes down to the controlling factor is where the person dies. So the second half of that is, can a person who lives out of state but intends on having their services in New York complete the agent form? You know, I mean, again, they can, even if they live out of state. I think it's a good document to give indication of what their wishes are. I think some states might honor that. I can't speak for them. Some states may not. But if you plan on having services in New York, you know, this is your hometown here in upstate in the Finger Lakes or, you know, Long Island, wherever you're at, and you want your final disposition there, but you're living in South Carolina or Florida or Texas, I would check with those states and see if they have a similar type of document. You could fill them out in both states just to cover yourself. You know, if Texas has their own form, fill that one out, fill the one out in New York State, make sure the funeral home has a copy of it, of both. And, you know, again, the controlling factor is where the person actually ends up passing away. The pre-need contract was done in 2021. At that time, the beneficiary named his POA as the agent. Okay, pre-need contract. Oh, I assume they're saying the POA was the agent in charge of disposition. So the beneficiary now has dementia and the appointed POA is in jail on drug-related charges. These things come up actually quite frequently at the Bureau. We hear it all over there. So there is a new POA who wishes to now be appointed as the agent. What should the funeral director do? Well, the funeral director really shouldn't do a whole lot because this is actually between these other individuals. So at the time, the beneficiary that was the beneficiary of the pre-need contract. So you're blending two things here: a pre-need contract and a 5211 form. It sounds like. So the pre-need is a specific contract. That's the funeral director has to follow that. In fact, 4201 says they have to follow any of the known wishes of the decedent if they want to collect the money from that account. So if the POA was the agent and is now in jail, there is a new POA. So I was thinking that the person with the dementia wasn't able to appoint a new POA. If there's a new POA, that new POA, and it's a legitimate POA, they can appoint a new agent. And the funeral director really doesn't have to do anything other than abide by that. Can a POA fill out an agent form? Power of attorney can fill out the agent form. The caveat there is that they cannot appoint themselves as an agent. This came up a couple times during my tenure, and I remember having a conversation with Mike Lenotti through email, and we did get an opinion from our Division of Legal Affairs at the Department of Health that said, yeah, it's under another section of law. It's not under 52, under, it's not under public health law. It's not under general business law, 453. It's under a whole different section about estates and whatnot, that the POA cannot use their powers to expand their powers. And so that would, and there's also a sub section that talks about POAs not being able to execute forms having to do with disposition of an estate or a decedent. So they can fill out the form and appoint a new agent, but they cannot appoint themselves and expand their powers. Next of kin question. Okay. A deceased leaves a handwritten note that has not been notarized or witnessed. I'm going to pause there right off the bat and say, good luck with that. Most courts in New York will look with a jaundiced eye on something like that if it's going to be used to support somebody's claims. The note says that his stepdaughter shall be in charge of his end-of-life wishes, and his biological children should not be informed of his death. What should the funeral director do? So the stepdaughter, this is, first of all, the red flag should have gone up as soon as he found out that this was a stepdaughter and the biological children are cut off, because the stepdaughter would be the child of a second marriage or something of that nature. So these are where we get these issues before. Just like on a 5211, a stepdaughter would not be considered a child during that, when you're making that list of who has the rights of disposition. An adopted child, on the other hand, does have those rights. So if you read 5211, I'm sorry, if you read 4201 carefully, it talks about who has those rights, and stepchildren are not included. So the long and the short of this is, as a funeral director, I would not proceed. I would make sure that, first of all, even if it says his biological children should not be informed of his death, that's not a binding thing that you have to follow. They're going to find out about it eventually anyways, and what you don't want is to have the biological children come back and sue you. So you want to make sure, even if you do move forward, that stepdaughter signs a statement saying she is the person in charge and that no one else was available or able to come forward, which may not actually be true, but she's going to need a little bit more ammunition than just a handwritten, handwritten note. It's not been notarized or witnessed. It doesn't even say if it's been signed. So anybody could put that together. You tread very carefully on this one. I think you need some more information here before you decide what to do at this point. But the funeral director should be extremely careful here. And as always, in a lot of these questions, you might want to consult with your attorney before you move forward in either direction. Ultimately, I think it was paragraph 8 in 4201 says that if there is a dispute, and like these biological children show up and they want to now claim control, you are held harmless to not move forward in either direction until they go to court and get a statement from a judge of who's actually in charge. What can or can't a resident legally do? As far as funeral directing, that is, I'm assuming. What can they do? They can do pretty much anything a funeral director can do, with certain things that they cannot. It's very specific that they cannot make funeral arrangements. They cannot sign a death certificate. They cannot present funeral merchandise. So, for example, you have a resident that's working there and somebody shows up at the door while you're out running errands, and they say, hey, can you show me your caskets and what the costs are? They can't legally do that. What they can do is hand them a general price list and say, here's our general price list. And in fact, that's not only can they do that, they're required to do that. So even if they're working alone on the premises and somebody shows up, they have to give them a general price list if they have any question about prices. And on the general price list, it'll show caskets range from this point to this point. You can't, as a resident, bring them into the selection room and show them the individual caskets, because that's considered presenting merchandise. And we get this question pretty frequently, that Can a resident make a removal without a licensed funeral director in the vehicle? Yes, absolutely. In fact, yeah, I would venture to say probably half the residents get hired because somebody, some funeral home needs help to cover transfers, just doesn't have enough staff. So it creates a market for residents to find work. So they can do embalming by themselves. Now they're still under the auspices of the sponsor. During the residency, they have to sign up on the application with the Department of Health. There has to be a specific sponsor list. If you read the regulation regarding residents, the sponsor is a licensed individual that is responsible for everything that individual does. So it's not a position you want to take lightly either, because you're ultimately responsible. If there is a violation, technically the department could go against your license as the sponsor if you were not maintaining proper supervision of what the resident is doing. And didn't vet them properly. So, there is some liability there, but usually it's not. It's only come up once or twice in the 10 years I was there, where there was issues with a resident and what they were doing things legally. For example, we had one resident that was offering himself out as a trade embalmer while he was working for the funeral home. Yeah, the resident cannot do that. They're under the sponsorship of that particular funeral home and that particular licensee. They can't go off independently and offer to embalm bodies in other funeral homes for pay. Similar situation on Long Island, we had a resident that was offering himself out to sign in funerals for other funeral homes at a local cemetery on his days off, and for $50 a pop, so they didn't have to send a licensed person through the New York traffic to get to the cemetery. Can't do that as a resident. But you can certainly do a final disposition. You can bring a body to a cemetery for final disposition. You can preside over a service. There's kind of a gray area there, because the way the law actually reads is that when you look at the supervision charges on your GPL and on your itemization, it says supervision of funeral director and staff. So we did have a situation where just the resident was left to do a complete service, and the family complained that the funeral director wasn't there. And when you parse it down like that and unpack it all the way, it does say you're charging for the supervision of the funeral director and staff. So in that case, we couldn't really let that one slide. But for the most part, they can do quite a bit. They're like a junior licensee. They can do the embalmings, they can do the removals, they can, sit in on services and preside over services. They cannot make arrangements, but they're encouraged to sit in on arrangements. They can't take preliminary information. That's not considered making arrangements. If a family walks in and the licensee is off, out doing some errands or something, and the family wants to begin the process, they can sit down with that first call card and gather all the information that the family would normally be requested of for the death certificate, for example. But they can't, do any of the actual arranging or presenting merchandise. And they can't do pre-needs. I've had a couple of directors over the years say, oh, no, I understand my resident can't do arrangements, so I let them do the pre-needs, and then I come in and read them over in front of the family, and I'll sign them. That's not legal. That's considered making arrangements. Can a domestic partner still be considered a domestic partner without living together? So 4201 does says the domestic partner of one person has to be the domestic partner of the other, which we think would be obvious. We've had this happen where somebody claimed to be a domestic partner because they had a joint checking account, but they hadn't lived together in some time. They just never closed the account after they broke up. The word domestic partner is the same word as domicile. It means where you live. So the term domestic partner means you are sharing a domicile, so you are living together. So the answer then would be no, you're not considered a domestic partner if you're not living together. If the next of kin are parents of the deceased and you only need 50% to sign the cremation authorization, what do you do if the parents disagree? Paragraph 8, 4201, they have equal rights. There's a dispute, they have to go before a judge. This actually comes up more than you wouldn't expect. And again, 42.1 is the ruling law here. You know, you only need 50% to sign the cremation authorization. And you don't want to get in the middle of two fighting parents who are probably divorced at this point or in the process. So if you have a child that dies and the parents are in disagreement, you are held blameless by not moving forward until they go to court. Is a trustee in a will the same as an executor? No, I mean, I'm not an attorney, and I don't even play one on TV, but my understanding is the trustee is in charge of a trust, and an executor is in charge of disposition of the assets of an estate. So a lot of people now are moving to this end of life planning where they'll create a trust to put all their assets in to avoid going through probate and that sort of thing. My father-in-law did that before he passed, and it was a real can of worms for my brother-in-law to settle that estate. So it kind of backfired. Didn't bother my father-in-law because he was dead, but a trustee is in charge of a trust and an executor is in charge of a will. So during life, while the individual is still alive, maybe they have dementia and they created this trust before they got too bad, and they've appointed a trustee. That person can distribute assets of the trust all the way up until that person dies, because the trust is now owned by the estate, and then the executor would step in and take over for that trustee. Who can death certificates be given to when there are multiple children, nieces, nephews, etc.? Specifically, if there's a family feud, are all the children entitled to a copy? I'm going to start by saying you are not even required to provide death certificates technically. The family, you have to file the death certificate. Death certificates are not free, other than the fact that you get, you know, the VA gives you, a veteran gets one free one. But I know several funeral firms that just tell the family, here's the information on how to contact vital records. This will be filed within the next 72 hours, and you can contact them about getting copies. And they, in fact, some of these same firms do no cash advances whatsoever. So if you do cash advances and order them on behalf of the family, again, you got to be specific of who you're going to give them to. If you know, if the son of the deceased is the one who made the funeral arrangements, signed the contract and paid the bill, he paid for them, you don't give them to anybody else. That's his property. So if he wants 10 copies, he can decide which nieces, nephews, and, you know, third cousins and whatever else gets a copy. But the funeral director should not make that determination. Okay, what rights does a funeral director have when they are in possession of the remains and the family refuses to move forward? This one, sadly, I would say in the last 9+ years I was at the Bureau, we got a call like this at least once a month, sometimes 3 times a month, where funeral director starts out in good faith, family calls them, they go do the transfer. Oftentimes they even meet with the family, got permission to embalm, and then when it comes time for somebody to pull out their wallet, everybody scatters and never hear from them again. That is technically an abandoned body. I'm not sure what the geographical spread is on this call. Looks like we're up to how many people? It's not showing me now.
Well, there's 288 computers, probably more than one person on each computer.
Okay, so this, if you're in the 5 boroughs, I know that the Office of the Chief Medical Examiner has instructed you that before you can return a body to them, you have to contact the Bureau. That has never been the case for 9 years. Me and the staff fought against that edict from OCME. But regardless of that, if a body's abandoned, that is the role of the county or the jurisdiction, the county or the bureau or the borough in which the death occurred or where the body is. The problem, I think, a lot of times with the OCME was that the person was not released to the funeral home from the OCME. They died in a local hospital, or they died in a nursing home. On one occasion, we had one that had died in New Jersey. The family wanted to have the service in New York, and then they walked away. And of course, the OCME was not willing to take a body of someone that died out of state. And of course, the people in New Jersey were not willing to come into New York and take a body that the funeral home had moved. So, but under county law, any abandoned body, whether it's abandoned in your prep room or abandoned on the park bench across the street from your funeral home, it's an abandoned body. And that's actually the origin of a coroner, was to handle abandoned property, and in the old days. And now it's come down through history as they deal with bodies and unattended deaths. So, and I've had this happen a couple times upstate as well, and have talked with funeral homes. They say, well, the coroner refuses to take custody or take charge. At that point, if you're in a county where you have a coroner, contact the county attorney, and they should be familiar with county law. But the funeral director at that point, if the family walks away, regardless of how far along the process they were, the funeral director has no legal authority to maintain that body there, and they have no legal authority to dispose of that body at that point. The family has abandoned it. Funeral home received a request for their general price list so that the organization and an organization can compile a price comparison with other funeral homes in the county. Happened to me all the time. Do they have to share their GPL? With the information given, I would have to say, if this organization sent somebody in person to the door of the funeral home, yes, they have to share their GPL. If this organization calls and says, please mail us a GPL, they're not required to do that. Both New York State and the FTC say you must give it to any person who asks for it in person. You also are required to give prices over the phone. I had an organization that hounded us for GPLs on a regular basis. They did like a quarterly update of their website, or it might have been every 6 months, comparing local funeral home prices. And I'd always tell them on the phone, you need to come into the funeral home. And they were like, well, I can ask prices over the phone. That has to be within reason. They can't have you read the entire GPL to them over the phone. Yeah, they can ask simple questions like, what does direct cremation cost? What is a direct burial cost? Forwarding remains, receiving remains. You can't go into so much detail that becomes cumbersome. And you can make that call when you think they've gone too far. But yes, if they come in person, you do have to give it to them. Can a non-licensed employee answer questions about a funeral bill invoice? A funeral bill invoice, that's on the business side. That's not public health law. That's not offering goods and services. I mean, funeral homes are businesses. They have a business aspect to them that has to be dealt with. They have office personnel. And a larger firm, they may have several different office personnel. And so, a non-licensed employee, you're talking about a funeral bill or an invoice that was sent after the fact. Final disposition has occurred, services are over. Obviously, there may be a bookkeeper involved. Family comes in with a question like, what is this charge for? They shouldn't go beyond their realm of knowledge. If the family sees a charge for, and this one we see it all the time. We'd have families call and say, well, I got double billed for supervision and use of facilities because it was on the front of the itemization, then on the back it's listed there again. That's where on that place where the FTC requires you to combine those two charges. So if your non-licensed person isn't familiar with some of these nuances there, they should be careful about that. And if they're not certain, wait until the funeral director gets there. But if it's just simple questions about what's this charge or what's the interest rate, or can I spread out on payment plans or that sort of thing, yeah, there's no issue with that. When filling out an itemization for direct cremation, do you have to include anything in the explanation of charges such as will be transported in an alternative container? So on your GPL, you should have two prices for direct cremation. One with your alternative container and one without, in case the family provides a cremation container. In all the years I was running the funeral home, I only had one family provide their own cremation container. guy was a kind of a woodworker, and when he became terminally ill, his boys asked if they could make his container for his cremation, and they went out in the garage and they built a nice little cremation container. So yeah, so that's why you have two prices. Rare, but families do occasionally provide their own container. So it should be pretty explanatory on the GPL and on the itemization that, you know, that they have selected an alternative container. And as long as I'm on the subject, when funeral homes would submit GPLs to us, oftentimes through a document demand during a consumer complaint investigation, one of the first things we would look at is the difference in price between their two direct cremation charges, the one with and the one without. Let's say if it's $150 difference, the next thing we do is we'd flip to the side where it says merchandise and you have your list of caskets. That 150 better be your lowest casket there, because we've had people put, you know, they have caskets ranging from 150 to 10,000, but the alternative container they're including in their itemization on their GPL is $500. You can't do that. It has to be the lowest priced container that you offer. And remember, alternative containers are considered caskets. They have to be on the casket price list as well. So you can't have a separate catalog of alternative containers and cremation caskets and burial caskets. They're all on one casket price list.
Would you like to do a few questions now, Tom?
Sure.
Okay. When giving prices over email, do we have to include our GPL?
No, that'd be considered like it's a modern day version of telephone price disclosures. My question is always, why would you not? You know, it's just as easy to email them a copy of the GPL. FTC, they never came out with a final ruling, but for probably the last 3 years, they've kicked around the idea that any funeral home that has a website would now be required to post their GPL on the website, because the website would be an offer to do funeral business to the public. And so they never came through with that. And I think part of it was because a lot of funeral homes now are moving away from websites and going to social media. And they weren't sure how to deal with that. That's my guess. But, you know, we've always told funeral directors, if you're not ashamed of your prices, why don't you publish them on your website? Why don't you mail them to people who want them? You know, but if you're dealing with a family and they want prices through email, at that point, you know, it'd be kind of silly to tell them, well, I'm only going to give you 5 prices. The rest you'll have to come in for, because you'll probably lose that call anyways.
Okay. Does a licensed funeral director, after signing in a funeral, obligated to go to the grave, or can they let the clergy or driver take over?
So the way this has always been interpreted in the past is that it's delivery to the place of final disposition. It doesn't specify to a specific plot and grave. For example, when I was in Syracuse, the local veteran cemetery, they would not allow the funeral staff into the cemetery with the casket. It was brought to the gates, and then the military people took over and transported it from there to the grave. Another example would be like Green Springs Natural Cemetery. It's a field, it's a meadow, and some woods, and they have a special transporting cart that they built. So the funeral director would come to the gates, put the casket, biodegradable casket, or if there was no casket, the shrouded remains on their transporting buggy, and they would wheel that to the grave with the family. Oftentimes we just stood by the car, maybe 200 yards away, let them do their thing. So no, there's nothing that says that they have to be actually inside the gates, and as long as they've got the signature that the body was delivered to that specific site. I wouldn't leave until you know that things have been finalized, just to be safe. But it's not specific about going to an actual grave site. Unless you're charging for grave site services, then of course you don't want to be charging them for something you didn't provide.
our county contracts with funeral homes to transport decedents to the medical examiners outside of the county. Now the county has purchased their own vehicle and the coroners are transporting themselves. Can a coroner, who is not a licensed funeral director, transport to a funeral home if a licensed funeral director is not at the place of death?
So if they're working on behalf of the coroner, yeah, anybody can be a mere transporter until that body is released by the authorities, and the coroner is the authority. So if the coroner is not a licensed individual, in a lot of counties that is the case, the coroner can transport the body from the place of death to the morgue or wherever that is. They should not, and I've had this complaint in one county a couple years ago where a coroner was offering to basically do transfers on behalf of a funeral home that he was friendly with. They can't do that. They can't do services that the family is then going to be charged for by the funeral firm. And my understanding was in this particular case, the funeral home was like splitting the cost with them. Like they charged the family $500 for transfer. Say, hey, you coroner, you can legally move this body. Go get the body. We'll give you $250. They can't do something like that. But again, a non-licensed person working on behalf of the coroner or the medical examiner is certainly legal for them to transfer the body till the body's been officially released to the family. And I always mention that when a body is released, whether it's from a nursing home, hospital, hospice, coroner, it's legally being released to the family. And the family is appointing the funeral home as their agent to receive those remains.
Can the funeral home charge to fill jewelry when it's purchased outside of the funeral home?
Sure, you can charge. If you do work on behalf of a family, you're welcome to charge for it. I know several funeral homes that do that. If you buy an urn from them, they'll put the ashes in the urn. If you bought an urn online and you bring it in, we're going to have Dad cremated and this is the urn he wanted. Well, there's a charge for me to put the ashes, and give the family the option. If you want to put the ashes in, go for it. But if you want me to do it, it's a $25 charge to cover my liability, or however you want to explain it. That's one of the reasons I never enjoyed marketing jewelry, because there was a lot of room for spillage and error. And if the family saw how much actually got wasted, that fell on the floor or couldn't get swept up, I don't think they would be happy about it. But yeah, if anything you do on the behalf of the family, as long as that's on your price list and you're doing that actual service for them, you can charge for it.
The next two questions have to do with an alternate container. So what if they have a casket that is less than the alternate container?
What if they have a casket that is what?
Less, price-wise, less than the alternate container.
Well, the alternative container should be the lowest price thing on the casket price list. Just like your alternative vehicle, you don't charge more for that than you do for the hearse. So unless they have like a $99 metal casket, and the first combustible one they have is 110, I guess you would have to go with that alternative container, because the crematory can't accept the metal casket anymore. So, but in general, the alternative container, that's like I said, when we would review GPLs, that's the first thing we'd look for, is the difference between the direct cremation with and direct cremation without. And if it's $150, we would want to see that their lowest priced alternative container is $150.
And
I'm sorry.
No, go ahead.
I was just going to say, so if you're offering an alternative container for cremations, that would have to be, the least expensive one.
Can the cemetery refuse to bury that alternative container?
It depends on the type of cemetery and what their regulations are. But, if it's a cemetery that requires a vault, they really don't have much leeway to say what type of casket or container goes in there. I actually made arrangements once, pre-arrangements with this gentleman after we had buried his wife. And when he was making the pre-arrangements, he noticed we had the alternative containers, the cremation boxes. They were cardboard. And he said, "Could I be buried in that?" I said, "There's nothing that would prohibit it. It is considered, an alternative container is considered a casket in New York State." So that's what he picked. Yeah, $125 cardboard box to be buried in. I left the firm before he ever passed, so I don't know if my replacement manager ever carried out his wishes or not. But now cemeteries can have rules about whether or not they have vaults. Like natural cemeteries, they're going to have rules that you can't have vaults, that you can't have certain caskets. So cemeteries can make those rules depending on whether they're religious exemptions or ecological exemptions. So they could refuse, but they can't refuse in one case and not in the other. It has to be part of their policy.
Can you address, on the FTC website, it says that you can't charge to fill an outside urn, but you can fill jewelry, or charge to fill jewelry?
So I'm not aware of that being that's on the FTC website.
That's what the question is.
Yeah, because that was not my understanding, because we've consistently said if you're offering that as a service and it's on your GPL, you can charge for it. The family, and I'm thinking more along the lines of the FTC is thinking that most of the funeral homes, most of the cemeteries in the country are actually owned by funeral homes or funeral businesses. That's not the case in New York State. So I haven't seen that on their website. I was not aware that they were making that claim or how long they've been making that claim. Our policy has always been, if you're giving a service to the family and you have to put forth effort to do that and it's on your GPL, that's your charge. Just like dressing a body. Nobody ever thought to charge a family for dressing until the FTC came around. And it was like, oh, we got to start itemizing everything we do. Hey, we spent an hour dressing a body. Can we charge for that? And the rule was, yeah, you're doing a service for them, put it on the GPL. Dressing and casketing is now a charge. But nobody ever thought of ever charging for that prior to 1980.
When you mentioned that sometimes when there's a dispute, it's best to send the family to court, what would be the first step in this? Would you need to contact your own personal attorney?
Well, 4201 doesn't say that you have to, but in that paragraph 8, it does say the funeral home is held harmless by not moving forward. So in other words, they can't sue you for not, and a couple of years ago, I did a whole biennium on 4201, and I had some lawsuits that I had gotten off the web regarding these kinds of disputes that I printed out. And there was one of them that dealt with that specifically. The funeral home was being sued for not moving forward at the family's wishes. They went to court, they won, and then they wanted to come back and sue the funeral home because the funeral that they originally wanted was delayed 2 weeks for the court action. And the judge said, no, he's held harmless. You don't have to worry about that. He did what was right. So you instruct them to go to court. And experience has been 9 times out of 10 when the family hears that they have to go to court, they usually work things out pretty quickly. And one of the tricks of the trade is you tell the family, okay, here's 4201, show this to your lawyer, contact the court, they'll put you on the docket, and our storage charge for your dad's remains is $110 a day. So if you have a holding charge for remains, make sure that's made aware to the family. You don't always have to charge it to everybody, but in cases like that, it's nice to have that in your back pocket and on your GPL.
Okay. What are we or staff to do when a family comes to us at church letting us know a family member has a keep away order from another family member at church? Do we need to call authorities or do anything?
Well, it probably isn't your best. It's not your obligation. It should be the family's obligation because they're the ones that are aware of the restraining order, and they're aware of who the players are and who's violating what. So if the family comes to you in the middle of a service like that at church and says, hey, they're not supposed to be here, you don't have any knowledge of that. You can't adjudicate that on the spot. I would instruct the family member, say, here's the phone, call the authorities. This is not our jurisdiction. Because if you're not correct, you might end up on the other side of some legal issues.
If the deceased is oversized and doesn't fit into a standard size alternative container for direct cremation, can the funeral director charge for an oversized alternative container if you place this charge on your casket price list?
Yeah, I mean, you can have different size alternative containers, and if it's something that's it's a one-off like that, like a special order sort of thing, that's where on the itemization on the back where it says, we'll explain to you in writing why we charged you for this. So that's where you would fill that in and say, oversized alternative container due to, volume of remains, or however you want to phrase that. But you can make those changes when it's necessary. It's not a violation. You don't have to have a special category in your GPL for obesity. That would just not be popular, I'm sure. But you certainly can charge for anything that you provide. And if you're too concerned about the repercussions, you might consider, when you do need an oversized, charge them at cost. So if they want to scream about it, just say, look, I'm not making a dime on this. But yeah, you can certainly do a change like that. Same thing that cemeteries do. If they have an oversized body and an oversized vault, they'll charge the family for 2 graves. The families generally don't balk at that.
Okay. What is the funeral home's liability concerning incidents stemming from the actions of family pallbearers?
So what is the liability of the funeral home for the actions of the family's pallbearers? Again, I'm not an attorney, so I'm going to phrase this carefully. You're acting as an agent of the family, and so are the pallbearers. The pallbearers are not your employees, and I think I'll leave it right there.
When an 18-year-old or older child dies that never married, but they have 2 living parents, the mother says the father is estranged, can the funeral director move forward with only the mom's signature on cremation forms? And would they be held liable if the father suddenly shows up and wants to be involved?
Okay, so again, the primary document you want to focus on here is the at-need statement. So mom says, I'm in charge because dad flew the coop, Papa's a Rolling Stone, he's out of the picture, he's moved on, so I'm taking charge. Have mom sign that at-need written statement, the person claiming control of disposition, and that protects you. That was one of those lawsuits that I printed out when I went through 4201 a few years ago. Was another situation like that where funeral home was being sued because the accusation was they allowed the wrong person to maintain control. And initially the judge was going to say, well, no, it's not his fault, but he neglected to have them sign that kind of a statement as required in 4201. So he kind of gave a split award to the complainant, and the funeral home did end up paying a penalty, but it wasn't the full request of the suit. So yeah, have mom sign a statement. Then if dad shows up later, he's going to take mom to court and not the funeral home.
Great. I will let everyone know that it is now 4 p.m. We are going to answer a few more questions if Tom has time, But at this point, if you need to get off, that is absolutely acceptable. We have a couple more questions in our question bank. And so, like I said, it's 4 o'clock.
Okay, talk fast.
Okay, Tom. Yeah. If a funeral director in New York has to take a body to Connecticut for a church service, and then the funeral director will bring them back to New York for the cremation, do they need to involve a Connecticut funeral director?
I would defer to Connecticut law, but in practice, I don't see any reason why they would, because they're not doing a disposition there, and they're not taking the body of a person who died in Connecticut out of the state. So, I mean, we have that happen along the borders all the time, where we have somebody dies in Pennsylvania, they come into New York for the services, and they are brought back to Pennsylvania for disposition. We don't require them to involve a New York State funeral director. So I think it would probably work the same way. It doesn't hurt to check, though, if you have that situation. Check with the local authorities if there's any requirement that there's any kind of a burial or transit permit or something that you have on your possession.
Okay, and along those same lines, if an out-of-state funeral director comes to New York for an interment in a New York cemetery, does the New York State, do they need a New York State licensed funeral director?
Yeah, unfortunately they do, because they have to, the way the law is written, it doesn't specify New York licensee, but throughout the, throughout Article 34, when it mentions a licensee, it's referencing a New York State licensee. So it says that, and when it says that a licensee must be present for final disposition or a registered resident, it's referencing a New York licensee. So they would need a New York State funeral director to oversee the final disposition. And Pennsylvania's gone the same way too. They want you to have, if anybody on the call is from the Southern Tier, you're probably familiar with this. It just changed within the last 10 years. I've taken bodies into Pennsylvania for burial and never needed any special permission, but now you have to get some kind of a limited license to bring a body into Pennsylvania. So if you do business along the Southern Tier, I think that's because all those crematories that were popping up in Pennsylvania. And I could be wrong. I've heard this through the grapevine. I haven't researched it myself, but I had a couple of people in the Elmira and Corning area ask me about it when they were told they had to get that limited license.
Okay, does New York State currently have any funeral home inspectors?
I'm not entirely sure, as when I left on August 31st, we had offered a position to a full-time inspector in the New York City region at the MARO, the Metropolitan Area Regional Office, that would be working out of the office on 90 Church Street in Manhattan. I haven't had contact with anybody at the department to find out whether or not that position was accepted. We interviewed multiple times over the last year for that. That position came up. We offered it out at least 2 other times. And the individual decided not to accept the position. So I'm not sure. Upstate, no. Downstate, in the 5 boroughs, you may by now have an inspector. What we do have is last year we had the Division of Legal Affairs for the Department of Health put a new bureau in there. They have the Bureau of Litigation, the Bureau of Hearings, the Bureau of this, the Bureau of that, within the Division of Legal Affairs. And they did begin a Bureau of Investigations. And in one instance, we're getting ready to go to a hearing on a firm in New York City, and the attorneys from the Bureau of Investigation for the Department of Health went on site and pulled the records and made copies. And it was basically not technically a subpoena, but because we have the right to inspect the records. So they were able to go in there and do that on behalf of the Bureau, because we didn't have anybody, we didn't have the boots on the ground to carry out that mission. So fortunately, there's more attorneys in the state employment than you'll ever see inspectors. That's for sure.
All right. If you have a casket display room, are you required to show the alternative container as the minimum casket offering?
Technically, yes. And again, if you look at the section that talks about caskets and alternative containers in the regulations, they're all considered caskets. So all your alternative containers have to be on your casket price list. Elsewhere in the regulations, it says you cannot display any of your caskets, lesser price caskets in a way that's different from your regular caskets being displayed. So since they're considered caskets, you can't like put miniatures out there or that sort of thing. You would have to display them the same way you display any other casket.
Okay, and if you display your outer burial containers, are you required to show a grave liner as part of your display as a minimum outer burial container?
And again, that applies to outer interment containers as well. They all have to be displayed in the same fashion so that you're not emphasizing, good, better, and best. Because it's all about consumer level playing field. So they, and I know there's, over the years, you've had different casket companies, involved companies come up with great marketing ideas, but they didn't actually look at the regulations before they came up with these marketing plans. And a lot of funeral homes implemented some of these good, better, and best kinds of philosophies without really thinking about what the law requires consumer-wise.
Okay. All right. This is a long one. Let me see if I can. Oh, can the at-need written statement be changed to say a majority of children 18 and older?
Well, there's the at-need written statement is not a form from New York State Department of Health. So most of the ones that are circulating are actually came from the state association. So I'm not sure what the current wording is on that, but 4201 was modified on May 8th, 2023 to say that a majority of people within the same class of having the right, for example, multiple siblings over one of the parents. If there's 5 siblings in charge of arrangements and 4 of them want cremation and 1 does not, majority rules. It used to be, had to be 100%. So I'm not sure what the at-need written statement that is circulating out there now says, but you got to go by whatever 4201 says. So if you have a statement like that that's no longer accurate, feel free to modify it. It's one of the few things that the regulations mention, but they don't come up with an exact format for. It just says they have to sign the statement. And I believe, I don't want to speak too much on behalf of the Division of Cemeteries because that's the Department of State, but I believe the cremation authorization, the DOS 1898, I believe they have modified that to reflect the change that Governor Hochul signed 2 years ago.
Are we required to give an itemized funeral bill to the children of the deceased if they didn't pay or sign the itemized statement?
You give the bill to the person who pays the bill. The itemization is just a statement of what the family selected. It's not technically the bill. So the bill goes to the person who's paying the bill. You release any information to any other family member, that's under 77.12, a charge of misconduct, because you're not allowed to share any information from the customer. Again, the customer isn't necessarily the next of kin. It's the person who paid the bill.
All right, we're going to do one more, Tom, and then I would encourage anyone else with questions, please feel free to email us here at the association. We're always here to answer questions. We're so thankful for Tom's knowledge and his hand-holding over the years whenever we had something we couldn't quite figure out. All right, so the last question is,
okay.
If you do not have a selection room and sell caskets and vaults out of catalogs, do you have to have a casket and vault price list?
If you don't have a selection room, you can always sell by catalog, and catalogs today include tablets and electronic catalogs, as long as they follow the rules about giving the correct information that's required in the regulation. So nobody's ever been required to have a casket showroom. In some cities in years gone by, for example, Syracuse had Marcellus Casket Company, was right on site. They had their own showroom, which is why the regulations still say you have to show your pocket card to any place of death or a casket showroom, because a lot of cities had their own casket manufacturers that had a showroom. So the local undertakers and funeral directors of the day didn't even have that. They just said, brought the family down to the local manufacturer and they walked through their showroom. So if you, if you want to save space and convert your showroom into a cafeteria, go for it. You can always sell through a catalog, as long as you follow the regulations there is what information must be given, and that all your caskets are all in one catalog.
Okay, thank you so much, Tom. We appreciate this. Everyone is commenting, congratulations on your retirement. And
Thank
we're
you.
just so thankful that you took time out of your new busy schedule to be with us and answer all the questions. And we're just so thankful for your knowledge. So at this time, everyone that's still on, the ending number is 21 in case you're asked. Again, I don't need it in case you are asked. Please allow 5 to 7 business days to get the credit reflected on your portal, and you will receive a letter in about 7 to 10 business days. Thank you so much, and I hope everyone has a good rest of your afternoon.
All right, thank you.